Hi there, folks. This is Sam Price, and thank you for logging into another episode of Probate Notes. And I have with me an attorney who's going to give us a very good insight into a way that a surviving spouse can receive some assets of the estate. Um, so I want to welcome my good friend, Aaron Feldman from Feldman Law Group in Walnut Creek, California. Hey, Aaron, how are you?
Doing very well, thanks. How are you,
Good.
Sam?
Awesome. Awesome. Thanks for being on today. I just wanted to get a little started with hearing a bit about you and maybe you could tell us about your higher education, and then we'll kind of talk about a little bit about your legal career.
Sure. I am from Southern California originally. So I ended up at UC Santa Barbara, which was great. Very good experience. And
That's got to be a fun school to go to.
it was a very fun school to go to. And I'm just old enough to have gone when it was almost free. So even better.
Wow. And fantastic location.
Yes, it is the best. And so when I went there, there was a decrease in enrollment somehow. And so they were really letting a lot of kids in who today wouldn't even get a look. The tough thing about Santa Barbara is very few people graduate in 4 years. My mom put her foot down and said, "You're leaving after 4 years." And so I had to catch up my senior year with like 20 units a quarter and for, but still managed to have a great time. Great concerts there. Volleyball was king back then. So that
Okay. Then what was your major?
political science.
Okay. That's an easy transition to the law. And what about law school?
So I actually took a year off between college and law school. I wanted to get into the entertainment industry, specifically the music industry. And I had a connection that got me a job at Warner Brothers Records. Um, so that was really, I thought was going to be really exciting. And what happened that year was the record industry tanked. And so in entertainment jobs, they start you like in the mail room, or in this case, they start you in the warehouse and kind of learn product and all about different labels that they controlled. And nobody got out of the warehouse. So I was in the warehouse. I was driving a forklift. And as the year kind of rolled around, law school started looking better. Law school was always like a plan B. That is what I decided I should do after the music industry seemed like a dead end.
Yeah. Um, you you and I had talked about a topic that I thought was really, really interesting. And you described it as if you're not looking for it, you don't see it. But once you know about it, you see it everywhere.
Yes. And the topic is community property issues that arise in a non-probate setting. And it turns out there's actually a probate code section that deals specifically with this area that I was totally unaware of. And once I heard a presentation about it, again, it's on your radar. And as lawyers, we are issue spotters. That's what we do, right? That's how you pass the bar exam, right?
Hmm.
So once you hear about potential community property issues, you start asking a couple of extra questions with that potential new client about various assets and what happened, and find out there are issues. The initial case that came to me was a pretty obvious one because the client was the one complaining to me about something that had happened after her husband died, where there was a very large bank account that her daughter, who was a minor, was the pay on death beneficiary. And I said, well, what was the source of that money? Did he inherit money? Was it his separate property? Where did the money come from? So when you start asking those questions, you find out, oh, they had a rental property together, community property, sold it. And then without her knowledge or consent, he took half of the money and put it into a bank account in his name with his daughter as the pay on death beneficiary. So that is what the code calls a non-probate transfer of a community property asset. And so there is a process of filing a petition to void that transfer as to the spouse's interest in that community property.
Well, really, this seems like the problem is that the deceased spouse can give away their half of community property to someone else. But really, the problem here is that if the deceased spouse gives away the surviving spouse's half of community property,
Yes,
really the big problem here.
correct.
Yeah.
So the surviving spouse file a petition, and it's mandatory under the statute that surviving spouse, the transfer is void as to the surviving spouse's interest in that community property, which would be half.
Yeah. And that's, I think, is probate code section 5020, 5020 at SEC. So that's about consent to non-probate transfers. And what happens when you file a petition based upon this probate code 5020?
Well, yeah, like any other petition, trust petitions, it's a very simple petition in terms of the substance of it. You just have to identify the asset and identify the parties entitled to notice. And so you're given a hearing date, and you serve it and go to a hearing, and theoretically it can be contested. It takes a lot of moving pieces for you to get to the point where you have to file that uh, petition, I think, because you have to have the other recipient of those funds disagree that they should give them back. So I turned down a case for a variety of reasons, but the surviving spouse, the husband had an account that was only in his name, but it was all community property funds. He left that account to 4 beneficiaries. One was a niece, one was another person. His surviving spouse got a quarter. So as to the 3/4, because this is where I think the math comes in. As to the 3/4 that were given away without her consent, I think she's entitled to half of that back. I don't think she's entitled to just 50% of the total account value. She's entitled to half of the non-probate transfer amount. I haven't, I didn't take that case, so I never pushed it to see if that type of calculation is the way it should be done. But it seems to me once you're doing things without consent, that it's going to bend toward the surviving spouse to the maximum.
It seems to me like this is kind of what if you have a married couple that are in a blended family, that typically the spouses want their own children to receive something. So it seems to be that uh, if the deceased spouse could give away their half, that at least so long as the surviving spouse receives their half of community property, that should be fine because that may be something that the parties would want anyway.
You know, there are families come in all types. I have a,
Right.
it is really hard if you have children from a prior marriage, then you remarry, and then your new spouse, and you have one child together, and your current wife, who you spend every day with, they want that child favored over those two before. And so there's always this conflict that exists in the estate planning. And, that's one of the reasons that we use those spousal consent documents sometimes in our blended family estate planning. Want to make sure we have things in writing. I had a blended family estate plan where I just found out yesterday that the wife passed away. And they had created an estate plan specifically that said, if husband died first, this is how separate property would be distributed to either his kids or her kids from the prior marriage. It was a very elaborate set of rules for what to do depending on which spouse died first and what funded and how much the children from the prior marriage would ultimately receive. But it was all very clearly negotiated in an estate plan that they both signed. So there was this consent inherent in that planning. But I could easily see where, without the two of them working together to work through how they wanted those issues resolved,